Good day, everyone. This is Attorney Don Green. I'm an attorney in Nevada and California, and as many of you know or might not know, the emphasis of my practice is on firearms litigations, gun-related issues. Today we're presenting a series of, and in the next few episodes, a series of timely issues which are critical for any person who is thinking about carrying concealed or is currently carrying concealed, because there's a lot of confusion on a number of aspects of the law of bare fear in Nevada and in some legislation which we'll discuss in another episode. Today, again, I have the pleasure of introducing Ms. Maggie Morgart. She's the Director and Principal and Chief Executive Officer of the Women's Defense Network. She's a recognized expert in firearms cases in Clark County and in Nye County, Nevada. Is that correct?
For sure.
Yes.
Done a lot of different cases across the nation.
Yes, and she's had training with the FBI and Quantico and Marines, and I didn't even ask her to describe that kind of training because I didn't want to get beat up. Well, anyway, so today we want to focus the attention of the listening audience and the viewing audience on a key element of self-defense, and that is bare fear. Maggie, tell us what bare fear isn't.
So bare fear isn't an idea that you're going to protect assets. Bare fear isn't an idea that maybe you think somebody's going to do something. Bare fear is insufficient to justify any sort of use of force, a deadly force that is, to defend property or thinking something's going to happen. Also, using bare fear, we look at, you don't want to do it in the spirit of revenge or self-righteousness. Someone breaks into your home and you're like, this is my house, so I'm just going to shoot you. There has to be circumstances that would excite the fear of a reasonable person.
So in Nevada, is bare fear defined, or does the statute present it that it must be a reasonable fear?
For sure. When it comes to that reasonable fear, we look at using deadly force. Deadly force is a force that could cause death or serious bodily injury. We look at the fact that true and present danger must be there. There should be a level of fear that you could be hurt to a level that would cost you your life or the life of even someone else, for that matter.
In my cases, when we talked about bare fear with the jury, we always tell them that the reasonableness is for the reasonable man to place himself or herself in that particular situation to determine if the fear was justified to display a firearm or use the firearm. Example, the lady at Walmart crashes into my car with a shopping cart while I'm loading groceries. Is that sufficient for me to draw my firearm?
She crashes into you with...
No, it's into the vehicle.
Into the vehicle. Well, the vehicle is a vehicle. If it's you, that would be you, but not so much, no.
What happens if at 9 o'clock at night during Christmas season that someone pins me up against the car with the shopping cart, and there's 2 or 3 people there? They don't have weapons, but they're big guys and they've got fists.
Hey, it doesn't.
What's the difference?
The difference is it's the asset of the vehicle is not in danger. We're not protecting inanimate objects. Now, if you're actually in a position where the force is being thwarted towards you with a shopping cart, and you have individuals who have pinned you in a position where they could actually hurt you and even cause death to you, because hands and feet, you can kill somebody with your bare hands. You have multiple attackers, you're by yourself. You don't possess a skill that you feel that you could use to defend yourself without a weapon. And we talk about a weapon. We are the weapon, but if we decide to integrate a tool into that, then that's going to be our force equalizer.
Bare fear requires that the fear of the great bodily injury or death be imminent.
Yes.
Define imminent for our audience.
So imminent is the immediacy of the danger. It's happening now. Maybe you are now recognizing that something has presented itself and it is happening in that moment. There's nothing else you could do.
So my grandson is being beat up on the other side of town. I live in North Las Vegas, and the fight is over off of Blue Diamond Road. can I take my gun and drive all that way over to Blue Diamond Road and display the weapon, or try to defend my grandson who's getting beat up?
I would say no. I would have those who enforce the law show up. They would probably get there before you did anyway. One would only hope that your nephew or whoever your family member is that's in danger would be able to defend themselves as well.
So we talk about the nature of the response. So is the nature of the response to be just as immediate as the threat, or close to it?
So it can be close to it. We look at if that immediate danger is happening and you cannot do anything else, you've exhausted all other efforts to get to a better place of advantage, to de-escalate the situation, to try to use less lethal force whenever possible. But I have to say, the firearm is a tool of last resort, and if they are forcing you now to use that firearm to defend yourself because that's the tool you've chosen, then so be it.
After school, in my yard, taking care of my grandson for a few weeks. He's in the 7th grade, and there's kids kicking him and beating them, and one of them takes his backpack and is going to hit him in the head, and I come out. And these are teenagers, obvious teenagers. What could I do with my weapon?
If you feel that your grandson is in a position where his life could be taken with this backpack that I'm thinking is probably full of books, could actually give him blunt force trauma, causing him to bleed out in the brain, I would say that if I was in that position, I would use whatever force is necessary to stop them immediately from continuing to present that lethal threat to my grandson.
So does the impression and observation of imminent great bodily injury or death, does that apply in the situation of defense of others?
It does.
And tell us how the defense of others is characterized in your experience.
So defense of others is witnessing that you're seeing someone, regardless of whether you know them or not, if they're a loved one, a family member, a friend, it doesn't matter who it is, we're protecting life. If we're in a position where we see someone who is offering that personal violence to them that could actually cause them death or serious bodily injury, we can actually then put forth whatever defense plan we have that could actually reach beyond two arms reach, and that would be that firearm. If we feel that we can get to them in time to be able to pull that person off, or even use blunt force with a less lethal force with another improvised weapon, we could even do something like that, knowing that we could actually cause serious bodily injury or death to that individual with blunt force trauma, with this very cup, if I needed to use it to defend that person who is now being hurt, who couldn't otherwise do anything for themselves.
What happens if I am mistaken in the defense of a person I don't know? What happens if I am mistaken about the nature of the situation? Let me give you an example. About 10 years ago, I was called upon to defend a man who was charged with display of his weapon, assault with a deadly weapon. When he went to, it was either the Costco or the Sam's Club over close to Red Rock Station. And when he walked up, there was this little old lady getting the crap beat out of her by this big biker type guy. My guy pulls out his weapon, says, "Get off of her and stop and stop." And the guy says, "No, I'm not going to." He said, "No, I'm not going to." The police came up. They talked to my guy. They arrested my guy for the display of the weapon because it found out these were the facts. The little old lady had just sold a half a pound of meth to this guy, and he shorted her on the money. She followed him from their apartment on West Charleston all the way to the front of the Costco or the Sam's Club, where she ran and she was assaulting him, and he got her on the ground. And she was the initial aggressor. She was the drug dealer. And the other guy, although, he was bigger than her, the citizen, would that be something a jury could factor in of whether my action was reasonable?
That is for a decision of the courts to make, and the mitigating circumstances. If this man was truly in danger by the elderly woman, one could see that would be reasonable. But in this case, I don't really feel that he was in danger. Let's
change the scenario. The punks from the gang in front of Walmart are displaying what appears to be a semi-automatic pistol. But in reality, it is an airsoft, and they cut off the orange tip. And when you see them draw that weapon on the little old lady to get her purse, and you're right there, what's the jury going to do? What is the jury instructed on your perception of the situation? Is it reasonable?
It is reasonable. It is reasonable in the sense that we don't know that that is a fake firearm. You can act accordingly based on the fact that you're being fooled into thinking that, this is a real gun. And so if we see that life is in danger and the presence of a firearm is there, we don't really have the ability to know whether or not that was, because the orange tip, as you said, has been cut off. They took away that recognition of the fake firearm.
So every situation about bear fear, the reasonableness of your action, the nature of the threat, the nature of the response, and the defense of others are all interdependent. Is that correct?
They are.
And so of this, there must be that immediate threat of great bodily injury or death, correct?
Correct.
And so, again, driving across town to save your son is not, in a general sense, the proper response to alleviate this situation.
Time waits for no one, and neither does crime. And by the time you get there, it's probably all going to be over with.
Okay. And is this what do you stress to your students the necessity to assess bear fear and keep that always in their mind?
For sure. Have some sort of plan put together, and knowing what you need to respond to and what you don't need to respond to, the should versus could.
Okay, because I had a situation personally where we saw a Metro officer who needed help, and I did not intervene, but I called 911 because I wasn't sure of the situation. The guy did not, it looked like he was trying to reach for the officer's weapon. I told that to the people on 911, but I did not intervene because I could hear sirens. Possibly the officer's already coming, maybe someone else called 911, but if I'd been carrying my weapon, at that moment, when the guy is not grabbing the police officer, would I have been justified in drawing my weapon? In an average sense.
In an average sense, you wouldn't really need to if the officer is in a position where he can still defend himself. I mean, there's mitigating circumstances that if the officer needs your help, also understand that if other law enforcement shows up and there you are with a gun, they may actually see you as the perpetrator.
So if the perpetrator grabbed the pistol from the officer and raised it up, and the police officer's on the ground, could a person exercising reasonable judgment draw his weapon and at least tell the guy to drop the weapon?
If time was afforded to you and you could tell that person, put that down or I'll shoot you, that could scare them, the idea of being shot, and that's if they even heard you, because audible exclusion could happen under that heightened sense of chaos.
Explain audible exclusion.
So audible exclusion is basically something that happens when we're under duress or stress. The ears tend to get a lot of blood flow to them, and it tends to shut off your sense of hearing, just like any other thing like sight. Or bradyopsychia, tachypsychia, maybe things are happening so in a way that they're now trying to apply some level that they think that they should do, but then realize they did something else. We look at even shunting of the capillaries of the hands and the forearms, all sorts of things when it comes to blood flow, the body's natural reactions to all those different things that could actually happen under duress or stress. And
through your training with HPP, and you're being at training seminars, and you're forming this successful new company, the Women's Defense Network. What do you tell your students about how to train for bear fear, or you just to have them recognize what can happen if you're wrong? They have to understand that there are so many different levels to prepare for when it comes to whatever force equalizer it is that you intend to use, whether it's a firearm, a knife, a balisong, empty hand defense, improvised weapons, all those different things. With frequent and realistic training, we can actually apply those things a little bit more natural because of the things that our bodies tend to go through anyway. So psychological preparation. So I'm writing a book, The Survival Triangle, and we have that physiological survival, the neurological survival. We even look at the aftermath of the incident, psychological
psychologically, what are you going to go through, and then that legal aftermath as well.
Thank you. And for all of you, you'll see on the banner at the bottom of the screen in the next few minutes, or right now in the next few moments, Maggie's contact information at HPP, Homeland Personal Protection, and the now successful program, Women's Defense Network, and you'll see my particular information as well, Don Green, 702-409-8239. We want to thank Ms. Morgart for taking the time today and providing valuable information. I'm sure you can always call her, and we'll be discussing these matters, and thank you so much. Signing off.